This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So it's always fun when one of these copyright trolling companies that seem to be based entirely around copyright trolling, it's always fun to watch one of them fail. And recently we've gotten to watch the schadenfreude of Malibu Media losing lawsuit after lawsuit after lawsuit after years. I mean, this is a company that filed some nearly 9,000 federal lawsuits since 2012, I think it was. And my role in all of that was I was one of the original defense attorneys. Malibu Media sued 5 defendants, or more than 5 defendants, but sued people in Pennsylvania where I was a budding green in the pasture copyright lawyer, wondering how in the world am I ever going to get to practice copyright law in Pennsylvania, where copyright law is normally for the entertainment industry, for New York, for LA, maybe a little bit of Miami now, maybe San Francisco now, but back then it was mostly LA and New York. Well, Malibu Media burst onto the scene, represented by Keith Lipscomb. He was from Miami, of all places, and they started this effort at copyright enforcement against BitTorrent-based file sharing, just, file sharing on the internet, like Kazaa and LimeWire and Napster and all that. But this one was based on Bram Cohen's BitTorrent protocol. Nothing illegal about BitTorrent itself, but like many things, you could use a tool in an incorrect way or improper way. And I'm not here to tell you all about the dynamics of piracy, but it is illegal to make copies or share copies of someone's copyrighted work without authorization. And so that implicates copyright law. We can always talk about the reasons for piracy and policy decisions and all that. And I personally think that going after individual file sharers is really not the way that you enforce copyright. But the U.S. Congress legislature has created a statutory damages regime, and that means that it's lucrative to go after individual streamers if you can actually get them to pay. So the method they came up with was capturing the data flowing on the BitTorrent file sharing swarm or the virtual network that is set up by the BitTorrent protocol, the peer-to-peer network. The company claims to become part of the peer-to-peer network, log the traffic, and then they subpoena individual IP addresses, or rather subpoena the identities of the subscribers behind the IP addresses. And one of those companies that did that, one of the original companies, was Malibu Media. Before Malibu Media, the entertainment industry, the music industry, and the movie industry tried to do it, but the kind of public backlash and the complexity and the damage awards were just not something that really paid off. So they stopped doing them. I think The Expendables was one of them in 2006. Sued over BitTorrent file sharing. And you've seen, if you've been on these networks, that there's lots of things out there being shared by BitTorrent protocol. It's not BitTorrent that's doing it, because BitTorrent is also a company. I want to be clear that we're not defaming BitTorrent here. There's nothing wrong with the company. There's nothing wrong with the protocol. It's the users can use the technology for file sharing illegally. Game of Thrones, for example, is one of the most popular pieces of content to pirate. And so could HBO sue all of the file sharers? They could try that. They could do this same thing. But maybe there's a little bit of public shame going on and lack of connection to damages and all that. And they realize that it's just not really lucrative. It's not really good for their brand. But adult entertainment companies don't have such shame, particularly Malibu Media. So what's happening here, where we are, is on a memorandum order and opinion where a defendant is going to win their attorney's fees after Malibu Media was unsuccessful in proving the defendant liable. We're on a civil liability standard here, and so it's not beyond a reasonable doubt. It's really up-down tug of war, who is more convincing, and the plaintiff was not able to convince the judge that the defendant was liable. but I don't think we got to a judgment. I think they dismissed the case. The judge is going to explain the rest of it, and I'll jump in where necessary. So this will be my reaction to this Malibu Media versus William Mullins attorney's fee award to the defendant. Malibu Media brought this action against William Mullins for copyright infringement. Mullins moved to dismiss and also filed a counterclaim seeking declaratory relief. Declaratory relief is literally where you ask a judge to declare that you're innocent, and it's a way that we preserve the right to these attorney's fees motions. Malibu voluntarily dismissed its own claim with prejudice, meaning the claim is adjudicated. It's as if the claim was found to be unsustainable. And Mullins' counterclaim was later dismissed as moot. Now before the court is Mullins' motion for attorney's fees and costs. For the following reasons, we grant the motion in part. The case began as a copyright infringement matter, but has regrettably devolved into a bitter dispute over attorney's fees. Malibu is a movie company that produces films for people over the age of 18. On September 21st, 2018, Malibu filed a complaint under the Copyright Act against John Doe, alleging that an unknown subscriber assigned to an IP address illegally downloaded, copied, and distributed 11 Malibu Media movies. Malibu later learned through a third-party subpoena request that the unknown subscriber was William Mullins. And I want to make a distinction here. William Mullins is a subscriber, but Malibu usually asserts that the subscriber must be the defendant, but we all know that can't be true, that every subscriber is also a defendant, because multiple people use one subscriber's internet account. You have separate users of these accounts. Subsequently, Malibu amended its complaint to name him rather than John Doe as the defendant. So now Malibu has made the assertion that the subscriber is the defendant. Mullins moved to dismiss the complaint. He conceded that he was the subscriber, but denied infringing Malibu's works, claimed others had access to his Wi-Fi. At a status hearing, the court asked counsel for Malibu whether the company conducts pre-filing investigations before naming individual defendants in copyright infringement suits. Counsel represented that Malibu does conduct such investigations, but that she did not know what information was available to us from the subscriber before filing the amended complaint. She nevertheless assured the court that we didn't just name Mullins because we could, but rather because we had a good faith belief that he was, in fact, the infringer. The court ultimately denied Mullins' motion to dismiss, concluding that Malibu had stated a plausible claim for relief. The standard is that it has to be a plausible claim rising above a mere possibility that the defendant is the infringer, even if it was not clear from the pleadings who used his IP address to download and distribute the movies. The court instructed both parties to engage in initial discovery, which means testimony under oath and the discovery or production of hard drives and things that are relevant to the case, and encouraged counsel for Malibu to share the findings from her client's pre-filing investigation. Mullins subsequently answered Malibu's complaint and filed a counterclaim seeking declaratory relief. The counterclaim alleged that Mullins had not infringed on any of Malibu's works and requested a declaration stating the same. At a status hearing a few months later, counsel for Mullins reported that certain information relating to Malibu's pre-filing investigation had not yet been turned over. She pointed to specific digital files which, according to her, would show whether Malibu had a good faith basis for filing its complaint against Mullins. In response, counsel for Malibu pointed to an email she previously sent Mullins' counsel in which she explained the findings of Malibu's investigation. According to the email, Malibu's investigator had discovered, in addition to the 11 Malibu movies discussed in the amended complaint, another 70 downloads from Mullins' IP address that were age appropriate to Mullins and his household. This information, however, did not satisfy Mullins' counsel because she wanted specific digital files relating to the pre-filing investigation. The court gave the parties 90 days to continue discovery. Counsel for Mullins later explained that the files in question are colloquially known as PCAP and reference files. According to counsel, PCAP files contain the raw data showing the transmission of information from an IP address to a monitoring system. Those would be the packet captures. That's what PCAP stands for, and that's the packets of information that flow across your internet connection, and it's what Malibu claims to record, and those are the evidence of the infringement. They record the BitTorrent PCAP files, and so the defendant's attorney had requested those files, appropriately so. In discovery, that's what you do. You request the evidence that the plaintiff has against you, and they apparently did not produce these things, according to this here. A few weeks later, Malibu moved to dismiss its own claim, as well as Mullins's counterclaim, with each party bearing its own costs and fees. But that's not how that works. You can't just dismiss your opposing party's counterclaims. Malibu moved to dismiss its claim because the time and expense needed to bear out Mullins's infringer status outweighed any potential recovery. The court dismissed that claim with prejudice, which means it's adjudicated, it can't be filed again, it's moot, but declined to dismiss the counterclaim because Mullins still had a right to clear his name of any wrongdoing. To help bring the matter to a close, the court ordered Malibu to turn over the digital files from the pre-filing investigation and suggested that Malibu draft a statement declaring that Mullins did not infringe Malibu's works. Malibu filed that statement. It declared that after learning of exculpatory information in June of 2019, remember the case was filed in 2018, Malibu believes that the infringement was done by somebody other than Mullins. Malibu reached this conclusion after learning that Mullins had not updated his internet password for over 10 years, shared that password with neighbors and guests, and owned a Wi-Fi system that reached nearby condominiums. This statement was not to the satisfaction of Mullins' counsel, however. Convinced that Malibu filed the amended complaint in bad faith, counsel continued to push for discovery and asked that the court again order Malibu to turn over the digital files that supposedly formed the basis of the amended complaint. The court issued that order at a status hearing a few weeks later. In a turn of events, Malibu's attorney then moved to withdraw her representation as counsel. This was probably around the time that Malibu's lawsuit efforts started to fall apart. I believe they ended up having to sell their house, the house where they conducted some of their operations, for lack of appropriate things to say on YouTube. They had been sued by their investors. They had been sued by, I think it was the Lori Lomnitzer law firm. And I believe one of them was a February 2019 or February 2020 default judgment where they didn't respond to a lawsuit from, I think it was their investors. I forget which one it was, but they didn't respond to a lawsuit. They got a default judgment against them for like $300,000. So something is wrong in Malibu Media's world, and they're falling apart. And I think we did a video on it called Malibu Media House of Cards or Copyright Troll House of Cards or something. And so I think the rats, for lack of a better analogy, the rats began jumping from the sinking ship. She explained that she could no longer appear on Malibu's behalf after having demanded from my client and given them a deadline for the production of the documents that Mr. Mullins' attorneys have sought. I have not received either those documents nor any reason that they cannot or should not be produced. The court granted counsel's motion, but not without warning Malibu that it still will need to turn over the requested files or explain why it has not. Nearly a year has passed since that warning, and Malibu has still refused to share the files. And this is where we start to get into adverse inference territory. If you don't turn over the evidence that the opposing party has requested or that the court orders you to turn over, the court will assume that the evidence shows something adverse to you and will infer that whatever the defendant is saying is probably more likely to be true. After the court dismissed Mullins' counterclaim as moot, his attorneys filed this motion for fees and costs. And there is a section 1927, 28 U.S.C. 1927 section that allows for recovery of fees and costs for unreasonably and vexatiously multiplying court proceedings. There's also the Rule 11, Federal Rule Civil Procedure 11 section meant to deter repetition of the conduct or comparable conduct by others similarly situated. The court also has inherent sanction or contempt powers. So then we get into the standards or the legal standards for attorney's fees awards, and we're going to try to skim through some of this. Under the Copyright Act, the court may award a reasonable attorney's fee to the prevailing party. That's the key word here, prevailing party, and that's Section 505 of the Copyright Act. Prevailing plaintiffs and defendants are to be treated alike, but attorneys' fees are to be awarded to prevailing parties only as a matter of the court's discretion. So the court has discretion, and these are the Fogarty factors from Fogarty v. Fantasy, a 1994 U.S. Supreme Court case. That's what this citation here means. When the court dismisses a copyright case with prejudice, the defendant is the prevailing party. There is a strong presumption that the defendant who prevails against a copyright claim is entitled to fees. This is no less true when a case is dismissed because the plaintiff threw in the towel. Among the non-exclusive factors the court may consider are frivolousness, motivation, objective unreasonableness. We saw that in the Akilah Hughes case. She was objectively unreasonable, and that's why the attorney's fees award went to Sargon. And the need in the particular circumstances to advance considerations of compensation and deterrence. That's from Fogarty. The court even calls them the Fogarty factors. While these factors help guide a court's analysis, the two most important considerations are the strength of the prevailing party's case and the amount of damages or relief the other party obtained. Further, substantial weight should be given to the reasonableness of the losing party's position, but courts still must take into account a range of considerations. So what does that mean? It means if two parties went to court over a totally meritorious, legitimate, sincere dispute over something, probably not going to get fees or as many fees as if one party goes to court with nothing, loses, and costs the other party a bunch of costs. And it doesn't seem to have a case to begin with, which is more like Malibu Media's position here. In any given case, a court may award fees even though the losing party offered reasonable arguments. That also means that a court may order fee shifting because of a party's litigation misconduct. Malibu does not dispute that Mullins prevailed on the infringement claim, but Malibu does argue that the Fogarty factors weigh against awarding fees. The court disagrees for the most part. Malibu contends that its claim was neither frivolous nor objectively unreasonable. According to Malibu, the amended complaint advanced the plausible theory that Mullins, the only adult male living in his home, downloaded and distributed Malibu's movies. And that's been my experience too with these types of plaintiffs. They assume that the adult, tech-savvy male of the household must be the infringer, because who else consumes that content? I can see the stereotype of the assumption, but I still disagree that that's enough to conduct one's legal business on. Malibu arrived at this theory after supposedly conducting a pre-filing investigation into Mullins and his IP address. At first blush, Malibu's claim doesn't seem frivolous, according to the court. Malibu owned copyrighted movies. Someone used the internet to download those movies. They retained an investigator to discover the other activity, and they served a third-party subpoena. But due to decisions they made subsequently, the analysis does not end there. First, counsel admitted at a hearing that she did not know what information from Mullins was available to Malibu prior to filing the amended complaint. This is especially troubling because counsel assured the court that Malibu only names defendants in copyright infringement cases when we have a good faith belief that the subscriber is in fact the infringer. But what gives the court even greater pause is Malibu's continued failure to share with Mullins and his counsel the digital files containing Malibu's pre-filing investigation. For nearly a year, Mullins has repeatedly asked Malibu for those files because according to Mullins, they would show whether Malibu had a good faith basis for naming him as the defendant. Inexplicably, Malibu has rebuffed those requests, failing to turn over the information despite several court orders to do so. That would be contempt of court. I feel like if I went to court and then didn't follow court orders, I would be held in contempt. So why is it just a fee and cost motion and not also contempt of court? We'll see if the court gets there. Malibu's continued unwillingness to disclose this information casts doubt over the validity of its infringement claim. As the court said on January 27th at the status conference, my suspicion is raised when documents which would prove that the case was brought in good faith aren't being turned over. It's that simple. The court cannot now conclude nearly a year later that Malibu's claim was neither frivolous nor objectively unreasonable. Against this, Malibu points the finger at Mullins, contending that he is the party that has withheld information. According to Malibu, Mullins should have come forward with exculpatory information sooner than he did, so that Malibu would know that multiple people had access to his Wi-Fi. The problem with this argument is that it fails to explain why Malibu has continued to withhold documents supposedly showing that it had a good faith basis for naming Mullins. No reasonable explanation has been offered, not even in response to Malibu's motion for fees. In the party's May 2020 status report, counsel for Malibu indicated that COVID-19 had contributed to Malibu's inability to produce information to substantiate its good faith basis for suing Mullins. But as the court noted in its order dismissing the counterclaim as moot, that representation warranted little sympathy, as Malibu had been directed to produce the information well before COVID-19 began. Furthermore, even if all the exculpatory information available to Mullins was not shared until June 2019, Mullins' counsel did share some exculpatory information before that date. At the first status hearing a month earlier, Mullins' counsel offered to turn over Mullins' computer for inspection and explained that Mullins lived in a building with a bunch of units that are all close together. Counsel further explained that Mullins and his wife made changes to their Wi-Fi after receiving a notice from their provider and also increased their privacy protections to prevent others from using their internet connection. What is more, Mullins' motion to dismiss the infringement claim, which was initially filed in February 2019, said that Mullins shared his Wi-Fi with guests as well as family and friends. While Malibu is correct that it was not under any obligation to dismiss the case at that point, Malibu cannot assert that Mullins and his counsel waited until June 2019 before sharing exculpatory information. Next, Malibu argues that fees are inappropriate because there are no facts in the record to support a finding that it had improper motive in filing its complaint. Mullins disagrees, arguing that Malibu employs a sue-then-settle strategy by which it seeks to settle lawsuits because it expects to lose money if they were to go to trial. But Mullins makes this argument with little to no evidentiary support. He relies on an expert report filed in a different case involving a different copyright holder and encourages the court to apply the report's findings to Malibu. The court declines. That does not prevent the court from recognizing that Malibu has been publicly criticized for being a prolific litigant. As one court recently noted, Malibu filed 7,183 cases nationwide from 2012 to 2018. Here in the Northern District of Illinois, a cursory review of public records shows that Malibu filed hundreds of copyright infringement cases during the same time span. This court alone saw 8 different cases filed by Malibu in 2018. All of this is not to say that Malibu's motivations in any one case have been misplaced. Nothing in the record leads to that conclusion, but the court cannot consider these figures without wondering what motivates Malibu's penchant for litigation, an interest in protecting its copyrights, or using litigation as a profit center. Certainly, most people who risk being identified in lawsuits as alleged downloaders are likely to simply settle the case as a means of avoiding public ridicule and embarrassment. We call them nuisance lawsuits. This court is not the first, nor likely the last, to pose these questions, and then they cite to a bunch of cases where other courts have posed the questions. At bottom, the motivating factor leads in favor of Malibu because the record does not support a finding otherwise, but for the reasons stated above, the court's conclusion is colored with skepticism. Considerations of compensation and deterrence. The factors weigh in favor of awarding fees because doing so may deter Malibu and similarly situated plaintiffs from bringing copyright claims against individual defendants without a good faith belief that the defendant has committed the infringement. While Malibu continues to argue that its infringement claim was brought in good faith, it has also repeatedly refused to turn over specific information from its pre-filing investigation confirming that is true. Malibu's counsel withdrew her representation for this very reason, among others. This is exactly the kind of behavior that should be deterred, especially to the extent it undermines the predictable operation and effectiveness of the Copyright Act's protections. Malibu also contends that Mullins should not be compensated because he undertook the risk of incurring attorney's fees. But that is not a basis for denying his motion. Mullins retained counsel in order to mount a successful defense, and he did so only after Malibu named him in the amended complaint. The final Fogarty factor weighs in favor of Mullins. To the extent Malibu argues that Mullins should not receive all his attorney's fees, that is a separate issue. Beyond the Fogarty factors, the Seventh Circuit instructs courts to assess the strength of the prevailing party's case and the amount of damages or other relief the party obtained. Here, the merits of the infringement claim were not reached because Malibu voluntarily dismissed it with prejudice. The court had an opportunity to review the amended complaint when Mullins moved for dismissal and found that Malibu had stated a plausible claim for relief, but after some minimal discovery, Malibu filed a statement rescinding its previous assertion that William Mullins committed any infringement of works as set forth in the amended complaint, and concluding that the infringement was done by someone other than Mullins. The court can reasonably infer from this that Mullins would have had a strong case if the proceedings continued. Further, the Seventh Circuit has stated that when a prevailing party in a copyright case is the defendant, who by definition receives not a small award but no award, the presumption in favor of fees is very strong. That is because without the prospect of receiving attorney's fees, the defendant might be forced into a nuisance settlement or deterred altogether from exercising his rights. Here, Mullins was not under pressure to enter into a nuisance settlement after Malibu moved to dismiss its own claim, but the motion said nothing about whether Malibu still believed that Mullins downloaded and distributed 11 of the movies. Malibu later clarified in a statement of non-infringement that it did not believe Mullins infringed its copyrighted movies, which I'm guessing was an attempt to get out of paying these fees by sort of throwing in the towel and walking away and saying, oh, we were wrong, sorry. And that way, I don't know, they cut off the fees. But still, I think the court, because I don't know what the outcome is yet, I think the court is about to say that, yeah, that cuts off the fees, meaning you didn't incur further fees, but you're still responsible for most of the fees up to that point. Maybe the fees from when the exonerating evidence was presented to when the case was actually dismissed. The court says, but that statement came months after Malibu voluntarily moved to dismiss its claim. Those embarrassing allegations still appeared on the public docket without any correction or revision having been issued. Mullins certainly had every right to exercise his defense to a successful conclusion, and without the availability of attorney's fees, he may have been deterred from doing so. Having considered the totality of the circumstances in this case, that's from the Kurtzang v. John Wiley & Sons Supreme Court case, the court finds that awarding attorney's fees in Mullins' favor is appropriate. The Fogarty factors weigh in favor of such an award, as do the other considerations discussed in this opinion. The court reiterates its belief that at first glance the case does not seem to be a likely candidate for a fee award. Someone using the IP address did infringe Malibu's copyrights, it seems. Malibu later learned that Mullins was the subscriber. Malibu then brought an amended complaint naming him. The court found Malibu stated a plausible claim for relief. That's the pleading standard. Nothing about these events is noteworthy. What separates this case from others is that Malibu has consistently refused to cooperate with court orders requiring it to turn over certain pre-filing investigation files that would purportedly show whether the company had a good faith basis for suing Mullins. Malibu's refusal not only constitutes misconduct for which fee shifting is justified, but also throws doubt onto the reasonableness of the claim itself. Malibu was slow to drop that claim and has yet to disclose the good faith basis, so attorney's fees will be awarded. So then the total fee award requested is $64,172. The court accounts for hours billed by the 3 attorneys minus voluntary reductions. Malibu makes 4 main objections. First, Malibu objects to fees relating to Mullins' counterclaim because Mullins was not the prevailing party. And so the judge does not agree that filing a declaratory judgment counterclaim fee shifts. Interesting. In the context of fee shifting provision, a judgment in a party's favor has such effect. Because Mullins' counterclaim was dismissed as moot, no judgment can be made in his favor. Therefore, he's not a prevailing party on the counterclaim alone. Malibu next argues the court should not award fees relating to his motion to dismiss because the court denied that motion. But as best as the court can tell, Malibu provides no basis for this argument. A party who loses interim rulings en route to ultimate success may still recover fees related to those interim rulings. Malibu's argument is rejected. They also object to fees incurred after November 12, 2019, the date in which the infringement claim was dismissed. The court agrees with this objection but extends the date to November 14th, which is the day the court held a status hearing to discuss those same issues. By the end of the hearing, it was clear that Mullins had prevailed on the infringement claim for the purposes of 505 fee shifting. In fact, the court remarked, quote, "I don't know what Mr. Mullins' motivation is to continue this in light of the fact that Malibu has said unequivocally that he didn't do it." So yes, Malibu was filing that statement of non-infringement to cut off further claims for attorney's fees. The proceedings following that hearing focused on Mullins' counterclaim and ongoing discovery requests, and while those requests concerned the good faith nature of Malibu's infringement claim, the claim itself had already been dismissed. There was little question he prevailed. So those fees will be excessive or unreasonable and inappropriate. The last objection is that the fees are inadequately described on the attorney's timesheets. While it is true that vague entries can support a reduction in fees, the Seventh Circuit has instructed courts to read timesheet entries in context, not isolation. Applying that instruction here, the court finds that it can evaluate some of the contested entries by considering the context. For example, two challenged entries read Lexis Research and Writing and Research on Redacted. While these entries are vague and exceedingly brief, the entries that surround them suggest that counsel was working on discovery-related matters. Other entries are impermissibly vague. For example, an entry on October 29th reading Research on Redacted. Counsel made no other entries that week. It is not clear to the court why counsel's research topics needed to be redacted, especially when no communications with the client were involved. Accordingly, the court instructs counsel for Mullins to prepare a new fee schedule that is in keeping with these findings. That schedule should not include any fees after November 14, 2019, other than the fees incurred as a result of preparing for this fee and cost motion and reply brief. So in other words, if you don't settle the fee motion and you have to go to court on the fee motion, you would get the fees for that too, if it's meritorious. The revised schedule should also not include fees incurred as a result of the counterclaim. Once a new schedule is available, the parties are strongly encouraged to find common ground, basically settle on the fee award. It is in the parties' interest, however, to bring the dispute to a swift and amicable conclusion, as this case should have been resolved long ago. For these reasons, the attorney's fees motion is granted in part and denied in part, and a new status conference will be scheduled for February 16th, 2021. That is the Honorable Thomas M. Durkin, United States District Judge for the Northern District of Illinois, Eastern Division. And so that's how Malibu is going to have to pay some significant portion of the $64,000 in attorney's fees. Also, $64,000 in attorney's fees to adjudicate what is probably one of the simplest copyright disputes. Maybe one of Leibowitz's photography cases is simpler, where one photograph was used with or without attribution on a website somewhere, or someone reposted, a paparazzi photograph on Twitter or something. This is a little bit more complicated than that. This involves BitTorrent and PCAPs and an expert witness maybe. But $64,000 in attorney's fees. Holy mackerel. I need to raise my rates, apparently, because I don't charge nearly enough money to require a $64,000 attorney's fee. But it did take 2 years, and it did take all this back and forth, and there was a motion to dismiss. So you can see how it gets there. It's sort of like the sky's the limit. You could do a basic defense, or you could do the spaghetti at the wall defense, and the closer and closer you get to filing everything you possibly can and having every dispute adjudicated in court means you could really rack up a bill. And in some way, the client is liable for that bill. The client owes the attorney whatever they agreed to, which isn't disclosed here, but there is some hourly rate or some flat rate or something that the client had to pay. So the client either paid all $64,000 and then we're trying to get the client back the money, or the client has paid some portion of it and the attorney's trying to recover the fee for themselves. You don't really know what the model is there unless it's disclosed, and it doesn't have to be disclosed. So this is still really remarkable. You can see what a sort of terrible job Malibu does in bringing its case and making its case. Doesn't really seem to care whether or not the defendant or the subscriber has actually committed the infringement. They seem to press the case as a nuisance lawsuit, and then only when they realize they aren't going to win, then they try to cut and run and pay as little of your fee as possible. It's not a really great litigation strategy, in my opinion, which is, I think, why you don't see even more of this. Because if this was completely permissible and there weren't consequences to the plaintiffs for filing barely plausible litigation, according to the court, it says this is plausible litigation, then you would see everybody doing this. And that's my concern with the Case Act. We'll put a bubble up there. The Case Act is the Copyright Small Claims Act, and I'm concerned that when the Copyright Small Claims Tribunal, the Copyright Claims Board, I think they're going to call it, the CCB, when it gets going, you might see many of these kinds of claims because the maximum damages in the CCB is $30,000, and many of these cases are worth somewhere around that. So 11 infringements times $2,250 per infringement is $25,000 or $24,500. So that's a lot of money. That makes it worth it to go to a copyright small claims court. Now, the Copyright Small Claims Court is voluntary, but it's opt-out voluntary, which means you have to affirmatively opt out, which means you have to respond in some way and opt out. You can't just wait to see if the plaintiff is able to make their claims. If you don't opt out, then you are opted in automatically, and that's one of the controversies. Of course, it sort of works the same way in real court. You know, if you get served with the lawsuit, well, you don't really have a way out. There's no opt-out. You're automatically opted in, and you must respond unless something extraordinary happens and the plaintiff dismisses its claim after it serves you before you have to respond. That doesn't happen. People either settle their case or contact the opposing party and make some kind of present some kind of exonerating information. So that's what this is. Let me know what you think about this copyright troll. I call it copyright trolling. This effort of copyright enforcement using packet captures from BitTorrent file sharing networks. I still disagree years later after representing in more than 1,000 of these cases. I still disagree that this is a proper way to conduct copyright enforcement. In my opinion, they could send takedown notices to the internet service providers that would at least give people a warning. And then if a copyright infringement claim comes later, I'm less sympathetic. You got a warning. You knew that Malibu Media or Strike 3 Holdings was going to come after you if you didn't stop, but you didn't stop. So that's a little less sympathetic. But they don't send warnings. As far as I've ever seen in my practice, I have never seen one of these cases where somebody said, yeah, I got a warning that said, don't download Malibu Media or Strike 3 Holdings anymore. You know, that's copyright infringement. No DMCA takedown or other warning went to the service provider. These companies could watermark their files. These are subscription-based entertainment companies. People pay a subscription fee. They have a username and password. And you could use something like, I think one of the services is Cloudflare, where you could put a digital watermark into the video files, and then whoever is seeding or sharing the initial file to the BitTorrent file sharing swarm, whoever's doing that would be track and traceable. And then you could nail them to the wall for maximum damages. But they don't do that to the best of my knowledge. And I assert that it's because they want to use these... They want to sue the consumers of piracy, not the perpetrators of piracy. Yes, BitTorrent shares as it downloads, so everybody's a little bit of a perpetrator in sharing as well. They more claim direct copyright infringement and not like vicarious or contributory liability. That is possible to be brought. But instead of going after the initial seeders, they seem to be going after the consumers, because the seeders are giving them more and more consumers. It's kind of like if the police were to go after the users of illegal drugs and not the dealers of illegal drugs. You know, it would leave sort of a business model for the police to keep nabbing the users, and maybe that's happened some places. I don't know. I'm not going to talk about that here. But anyway, that's what's going on. Let me know what you think in the comments below, and thanks for watching.
Thank you for watching. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program, here on YouTube, also on Floatplane, and on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern. Our channel is community supported by your monthly financial contributions on patreon.com/ljfrench, sponsors.com/law, through YouTube membership, and through Floatplane subscriptions. Thank you to the following $50 plus supporters in the month of January: Joe Tyson, Mitchell Rowton, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Andy, Benjamin Hitov, Goliath Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, HotGrillsInYourArea, Torpedan, Brandyn Abel, Cassandra Curran, Sovereign Tittizen, ShadowTycho, RDHDragon, Earthbound Star, Nathan McCarty, and Awful Asses with Lemon Fresh. And thank you as well to the $5 plus supporters who are scrolling on your screen. I hope everyone has a great week. I will see you in the videos that drop. I love you all. Bye.